All right. Welcome, everyone. My name is Eric, and it is my pleasure to introduce Haydn Belfield. Haydn is a research associate and academic project manager at the University of Cambridge's Center for the Study of Existential Risk, also known as CSER. His primary research is on the security implications of artificial intelligence. I also want to introduce Xin Hua, who unfortunately could not be here with us today, but who is Haydn's co-author on all the work that today's talk is based on. Xin is a research affiliate at CSER, and she is a competition and tech lawyer who has represented clients before the European Commission and other global regulators. So I'm going to turn it over to Haydn in just a second here. Reminder that throughout the talk, feel free to submit questions on Swapcard in the chat or questions tab of the app. And then we'll read through those during the Q&A following Haydn's talk. We won't be able to do any hand-raising questions, but submit all your questions there, and then we'll be able to have a great discussion. Please join me in welcoming Haydn.
Thanks very much. Great. Hi, everyone. Thanks for coming along. I'm Haydn Belfield, Cambridge University, and let me just see if this works. There we go. This is Xin Hua, who's my co-author on all the work I'll present today. She can't be here today due to family obligations. So we've been working together since 2020, I think, just before the pandemic hit. And we've written about 5 papers together. I'm going to present the results from 3 of those papers today. So Xin is the proper expert on antitrust and competition law. I work on AI governance, so anything that is at all useful that I say today can be attributed to her, and anything that is wrong is, of course, my stupid fault. So in this talk, I'm going to explain or make an argument for why we think competition law is so important as a lever, as a tool, both in the near term and in the longer term. So in brief, it's a very powerful lever, sometimes synergistic and sometimes in tension with AI governance goals, and I take AI governance goals to be the kind of responsible development and deployment of increasingly advanced AI systems, so safe, broad benefits, beneficial, secure. So the talk, I'm going to do 5 things. First, I'll introduce antitrust and competition law for people who aren't familiar. Second, I'll discuss a possible tension between the antitrust and AI governance. Third, I'll discuss a synergy. And then fourth, I'll suggest that antitrust may be enforceable and important over the long term. And then I'll end with some suggestions for people in the audience about what you can do. But I will start by telling you the story of a tech entrepreneur and billionaire. So this tech entrepreneur dropped out at age 20 to launch his first startup. This was a pretty successful startup, so he reinvested all of his gains in his second startup, which was hugely successful. He became one of the richest men in America, gave away his fortune to a variety of causes, including health, racial justice, universities, research. His company produced products that were used in almost every home in America. However, the company was criticized for damaging effects on society and politics and for reducing competition and innovation. So I don't know who you might be thinking of, but the person that I have in mind is John D. Rockefeller and his company, Standard Oil. So Standard Oil at its peak in the 1890s and 1900s controlled 91% of oil production and 85% of final sales. It was this incredibly dominant force. So how did it get so large? So this is a cartoon from the era. You might be able to see there, maybe not. Here's the Standard Oil kind of octopus reaching out its tentacles and pipeline tentacles to control the banks, the railroads, the producers, the refineries, everything. How did it get so large? Well, a government report from the time concluded that beyond question, the dominant position of the Standard Oil Company in the refining industry was due to unfair practices, to abuse of the control of pipelines, to railroad discrimination, and to unfair methods of competition in the sale of the refined petroleum products. So what did Standard Oil do? It formed cartels, it merged with its competitors, and when it had a near monopoly, it abused that market power, its dominance, to raise prices and to suppress competition. It also, skip to the next one now, an even better Standard Oil octopus, it bought lobbyists, it bought politicians, and it had powerful defenders in Congress. So this concentration of unaccountable, abusive economic and political power in one hugely powerful octopus proved very concerning to politicians and judges. And indeed, modern antitrust law in the US and abroad was developed largely against Standard Oil. So there are three bases for illegal bases for antitrust law, and it's the Sherman Act of 1890, the Clayton Act of 1914, and then the 1911 Supreme Court decision that finally broke up Standard Oil into 34 competing companies. So those three things can be seen as like directly trying to take on this behemoth and split it up and be able to control this, this massive concentration of economic and political power. So Rockefeller was by far the greatest robber baron. I think he was the richest man in US history and the richest man maybe in modern world history. But there are many others. I mean, we can see here we've got steel beam, copper, rail. I mean, some ones that might be familiar to people in the audience are like Carnegie, Andrew Carnegie and US Steel, Vanderbilt and the railways, all these robber barons from the Gilded Age of the US politics. But I'm going to suggest that this destructive power of monopolies and, on the other hand, serious government action to try and tackle them is not a new story in US or world history. So I've kind of already gone into it, but I'll go into this first section, which is a brief little overview of antitrust. And then I'll go on to talk about these next stages. So there's lots of kind of examples of these huge concentrations of economic and political power throughout world history. So some of the ones that, some of the earliest ones, I would argue, are the East India companies of the kind of colonial empires, but when they were corporate colonial empires of the British, the British East India Company, the Dutch East India Company, French. These were giant monopolies. They used their colonial wealth to fund bribery in the imperial center so that the politicians defended them. And in the mid-1800s, many of these were nationalized and ended because that concentration of economic and political power was too much. So I've already talked about this, the US progressive era trusts. One thing that I think is less appreciated, but I think is really interesting, is that after World War II, the Allies broke up many of the big conglomerates of Nazi Germany, such as, I'm going to mispronounce this, Vereinigte Stahlwerke, or IG Farben, and the Zaibatsu of Imperial Japan. So this is groups like Sumitomo and Mitsui. And this is because of a concern that this, again, concentration of economic and political power of corporate wealth had supported fascism in those two countries in the interwar period. And then kind of later, it doesn't have to be just about kind of breaking up these big companies. In the 70s and later, the US subjected two huge corporate giants, IBM and AT&T, to sustained antitrust scrutiny. And they did the same to Microsoft in the late 90s. And this kind of reduced their dominance in the market, and it enabled competitors to actually get going and to start competing with them. Over the past 2 decades, one that might be less familiar to people, Gazprom. It's the kind of Russian gas company. Over the past 2 decades, the European Union has brought competition cases against Gazprom to try and increase competition for gas and reduce Europe's dependency. So without them, Europe might be in an even worse state right now. And then, of course, the tech giants that would be familiar to many here in near Silicon Valley. So Apple, Alphabet, Meta, all of that. They are now actually larger than US Steel and Standard Oil were at the time, measured by profits relative to domestic GDP. So that's, I think, and you have seen in response quite sustained antitrust scrutiny from the European Union and from the US and others. So that's kind of just the kinds of, at the very largest scale, what we're talking about, and the kind of scale of power and influence and control that can be reached in the corporate world. Why are monopolies and restrictions on competition harmful? if these were fine, maybe we just let them go. Well, 420 years ago, the 1602 case of Monopolies in the UK, very famous, found that monopolies raise prices and they reduce quality and they damage all as its purpose is private gain. So this is quite like an abstract sense, but I quite like it because it really just gets to the core of it. Like this is what monopolies do when they have this market power. They use that power to raise the prices that consumers pay. They reduce quality, they reduce innovation, and they seek to defend that. So at the real core of antitrust is monopoly power or market power. So significant market power allows a firm to act independently of its competitors and ultimately its consumers. So in other words, it lacks the rivalry and competitive constraint to lower prices, improve quality, or innovate. There are 4 key areas of modern antitrust, and all can be thought of in relation to this like monopoly market power thing. So abusive dominance is, you can imagine a monopolist exploiting its market power to force its consumers to buy not just one product from it, but several like tied products or bundled together products. Cartels, collusion, anti-competitive agreements. We can think of these as like different companies getting together to jointly form a group that allows them to act like a monopolist. So, but this really applies, this kind of section on cartels applies to any coordinated practice between companies that restricts or distorts competition. Finally, like the third major element of modern antitrust is merger control, covering mergers and acquisitions. And this can be thought of as like these companies getting together to formally form a monopolist or reduce competition. And then, you know, forgive just this overview. I think these are important things to just bear in mind. The fourth one is state aid, which is a lot more common in Europe. The US seems very comfortable with state aid. So basically, this is concerned with state support for kind of national champions or big companies. So giving them tax breaks, giving them subsidies, reduce land. So we can think of like, you know, when big companies are deciding where to put headquarters, they often are offered tax breaks to place themselves in various parts of the US. You can't really do that in the EU. So those are the kind of 4 key main areas of competition law, modern antitrust and competition law, and we're going to kind of return to these throughout. Yeah, so antitrust is known as competition law in Europe. Most of Shinchin and my experiences of the European Union, but almost most of the stuff we're talking about is pretty like more at the level of kind of abstract analysis and carries across to US antitrust law as well. So in Europe, competition law has always been a cornerstone of the European Union. It's really in the like very foundational agreements from the 1950s on the European Steel and Coal Community and the Treaty of Rome. So it's like really goes back right to the very beginning. So maybe you can't even read that. I don't know. What I'll just kind of go through them. So the important thing to note about competition law is that it's like a very powerful tool. So it has jurisdiction over any company that's within its boundaries. So like even if you're not based in the EU, if you're operating, if you're selling goods and services in the EU market, the EU competition law can capture you. Same for vice versa. It's got really strong procedural and investigative powers. Really, like in some ways, like much stronger than other branches of the federal government or of the EU. So it can sanction up to 10% of global turnover, or even at its most extreme, break up companies. Or it can accept like very substantial remedies. So it stops the case, which can be like giving access to your competitors to your like essential IP or essential infrastructure. So yeah, really, really strong procedural and investigative powers, and very willing to use them. So regulators are institutionally strong, they're well-resourced, and they're very influential, and they coordinate worldwide. So I think this is like really one of the strongest and most active arms, certainly of the EU, but also of the US state. So and then it's going to increase in powers soon, because in the EU, the UK, and elsewhere, they're introducing something called the ex-ante regime. So at the moment, a lot of competition law is like ex post, and it kind of looks like, oh, what was the effect of this whatever decision, corporate consolidation? Oh, it had this bad effect. Oh, that's a shame. Maybe we should learn differently. The ex-ante regime is shifting to having a focus on specified gatekeeper companies. that have strategic market status. So these are like most clearly the big tech giants. And these companies are going to be required to follow codes of conduct, and there's going to be additional inspection powers for the regulator to go into these companies to like look at their algorithms, themselves. So one kind of indication of this is the level of fines. This is EU fines against tech companies, and you see here it's in the billions. What I want to be just like very clear, maybe I'm laboring the point, but we're really not saying big is always bad. We're not saying big can't be competitive, can't be innovative. We're not saying that breaking up is the only option. There's a whole host of kind of scrutiny and remedies and fines that you can do before you try and do the proper structural separation, which is breaking up. And we're not saying that the only thing antitrust can do is slow down progress. It can instead affect the kind of the number and nature of AI developers, and it can affect the behavior of those developers. But what we are saying, there we go, is that antitrust is a powerful tool, indeed one of the most powerful tools that states have over private companies, and it is both in tension and in synthesis with AI governance goals, which I've said previously is responsible, safe, and beneficial deployment of AI. Cool. Okay, so that's that's like a brief overview of antitrust. So hopefully we're all on like broadly the same page. We kind of know a bit about the history, and we know a bit about like these like 4 main areas, and we know like what's antitrust concerned with, concentrations of economic and political power, right? Great. So I'll now go on to like the more like actual AI governance-y bits and talk about 3 of our papers. We can talk about like some other papers we've written in the Q&A. So first one is I've actually got it printed off here. This monstrosity of a paper. US law journals really like very, very long papers, and we actually we've got like very long appendices to these as well. So so this was our first one. It was in the Yale Journal of Law and Technology. And yeah, so this is the title: AI and Antitrust: Reconciling Tensions Between Competition Law and Cooperative Development. So what was the inspiration for this paper was another one that I was involved in called Toward Trustworthy AI Development: Mechanisms for Supporting Verifiable Claims. So back in 2020, we published this. This is, I mean, you might be able to see here, there's just like a long list of various people from tech companies and others. So we got together to come up with 10 concrete suggestions for how companies could be more trustworthy, and a lot of these things was how they could cooperate together to do things that are beneficial, do things that are, that show that they are more trustworthy, like better audits or collaboration on safety or things like that. So this was the motivation. We were like, wow, this is so cool. We want to ensure that this can be functional and can work well. There's lots of these competition proposals. We want them to work. Cooperation proposals. However, there's this question about how to achieve that consistent with competition law. So clearly, there's some inherent kind of like theoretical tension there between the goal of antitrust, which is prevent cooperation, promote rivalry, promote competition, lack of information about what your competitors are doing, so you're constantly motivated to like compete fiercely, and then cooperation, which is like will have more information and may kind of like reduce those competitive pressures. So I'm not going to go into too much of the details about the legal arguments. For more, you can read that. But hopefully, it'll just give you a kind of like a bit of an overview of why we think there's some tensions here, but crucially, why we think they can be resolved if sensible steps are taken. So yeah, this is just to give you like a very high-level overview of the paper. So these are the 14 different proposals we talk about here. They're kind of grouped. The blue ones here are kind of like more long-term proposals. These ones here in the middle are kind of about monitoring, information sharing. And this one down at the bottom here is about standard setting. So there's things there like the assist clause, the windfall clause that might be familiar to people, things like third-party auditing, having standards around benchmarks or standards around secure enclaves. Yeah, I'm not going to talk about this in that much depth, but I will talk about like just 2 of them very briefly. So the first one is standard setting. So it can be really useful to set standards on a variety of topics in AI governance. So for example, the Partnership on AI is doing some really useful stuff on About ML or on Safe Life or on others. So yeah, a standardization agreement is, it gives some technical or quality requirement that products or methods, processes should comply with. So very important, very useful, could be very useful for promoting trustworthy AI development. But there's concern there if competitors are excluded from standard setting processes or access to that final standard. So what do we say? Well, you totally can go ahead with standard setting. You, in fact, should. But just make sure that it's on fair, reasonable, and non-discriminatory terms, voluntary where possible. So when these processes are going, have them transparent, have them open to competitors in the marketplace, and then once some standard is developed around hardware security or publication or release norms or something like that, make sure that everyone can access that standard equally. So it's not that you can't do this cooperation. It's just like do it in a sensible way, and then there won't be any problems. It won't raise any concerns, in our view. The second one is about kind of monitoring or information sharing. So there's, again, just to talk about the partnership, because the Partnership on AI brings together like 100 of the leading AI companies and a civil society group, so it's like an interesting one to talk about in terms of standard setting. They're like very clearly, they would be the kind of like industry association. So they've currently got things like an incident database that they're hoping to build up. Yeah, there's other kind of suggestions about, could you do mutual monitoring? Could you do mutual audits? Could you do things like that? So yeah, could you do red teaming, where a team from one company kind of tries to critique and attack the models of another, or the systems of another company? And yeah, again, there could be some really, really useful stuff here, some really important stuff that would help companies work better together and help them be more trustworthy, make more verifiable claims, so we can actually check that the claims they're making about oh, we're developing AI ethically, we're developing safely, we can check whether they're true. But again, you've got to be careful, because you don't want to be sharing commercially sensitive information. So that's things like, on this date, in the future, we're going to be releasing this product, and we're going to be selling it for this price, and this is how much it cost us to develop. All of that stuff you want to be careful about, because that gives your competitors information that they can use to oh, great, you're selling it for that price, we'll sell it for that price as well. And you can imagine that there could be the development of something like a cartel. So you want to be careful about commercially sensitive information. But so the suggestions are just minimize that kind of information exchange to only what is strictly necessary for the immediate purpose. Do you really need to be doing it if you're talking about here's some new safety research that we've done. You don't need to be talking about how much it costs you to develop your language model or whatever. And then a lot of these suggestions are work through a third party. Don't do it directly between the two of you, but instead work through a civil society group, industry associations, something like that. Something that's more broad, that can anonymize and aggregate information. So I've just talked about those two just quite briefly. But yeah, so the takeaway from all of these 14 is exercise caution when you're doing this. Be careful. But it's not like a blanket ban. It shouldn't, no one at these companies should be receiving legal advice of oh, you just can't talk to these people at all. You can. They shouldn't raise concerns if the safeguards are followed. So yeah, that's the first paper that we did. There's obviously a lot more in this that I'm not going to go into, but I don't really know what I'm going to do with this. So if somebody wants this after the talk, we can have a bidding war for it. Okay, so that was the first paper we did, which was about a possible tension between antitrust and cooperation and AI governance, and how we think that can be resolved. So secondly, another paper, the next paper I want to talk to you about is a possible synergy. So this is looking at the supply chain for compute. So the full title is Compute and Antitrust, regulatory implications of the AI hardware supply chain from chip design to cloud APIs. So there's some really cool things in the AI supply chain. It's like really remarkable. It's almost, when you read into it, it's like science fiction qualities. So the way you make really high-end chips is you have to have like this laser shining, this laser etches a pattern on a silicon wafer that you then put transistors on. And this mirror is so precise that if this mirror that is shining the laser to scratch the thing, if that mirror was the size of Germany, it would be so perfectly like flat that the only gap, the only like slight bump would be less than 1/10 of a millimeter. If the whole mirror was. So it's this incredibly precise like level of precision and scientific achievement. The laser they're shooting is so accurate that like if you had a laser pointer, you could, and we're on the moon, you could hit a thumb on Earth. Like it's this incredible like science fiction levels of accuracy, but you also see it like later in the supply chain. So AlphaGo Zero, I think it was, played 4.9 million games of Go against itself, just like really, kind of superhuman science fictional levels. And then, so the biggest public AI model to date when we wrote this paper, and I believe it's still the case, is Wudao 2.0, a Chinese language model. It's got 1.75 trillion parameters, and that's roughly similar to the number of synapses in a mouse brain. So just this, the supply chain for computers is really a wild, really remarkable thing that is very interesting, and I would encourage people to dig into. So what do I mean by compute? We're talking about a specialized stack of software and hardware, including processors, memory, networking, engineered to support AI-specific workloads or applications. So you'll often like hear people talking about compute in AI. It's like the computing power that is that models are trained on and run on. So what the paper does is it argues that this kind of topic of compute and the supply chain for it is underexplored in the competition law literature. And then these two, the one to bold, I'm going to talk about a bit more. It also makes the argument that compute is a major input to and driver of AI progress and of market power, crucially, and that when you look at the supply chain, there's just like massively high barriers to entry and incredible concentration along that supply chain. And then the better regulatory target I'll talk about in the next section. And there's just like a few case studies that we can return to, and I can test you on if you remembered what the four were from earlier. So here's a great graph from some colleagues, Jaime Sevilla, who's at EPOP and others. So this is a big one. What the amount of flops used in the biggest training run to that date. So in 2012, AlexNet is somewhere here, right there in the middle. And then up to more recently, things like Gopher, Megatron, and like GPT-3, people might be more familiar with. So the takeaway that from this is that in the last decade, 2010 to 2021, the amount of compute used in the largest training runs has been doubling every 6 months. It's been getting bigger. And one of the largest ones is 600,000 times more compute than was used in AlexNet just a decade ago. So it's becoming this like really, really like central part of how AI is developed and how it goes forward. And people may be familiar with like the concept of scaling laws. And yeah, it's referenced quite a lot. So that's the kind of make the argument that it's this really like it's very, very central to AI progress and to market power, right? So this is how we've laid out what the supply chain looks like for AI hardware and compute. So it goes from the left to the right. There's the chip design. There's chip fabrication. There's chip assembly, testing, and packaging. And then these are often kind of bundled together in these big cloud computing centers. And then something is trained using this cloud computing services. And then it's put to some end use. So yeah, you can see here that some of the key inputs are things like the mirrors, the ASML laser shining that I discussed earlier. Sorry, that's semiconductor manufacturing equipment. things like, so chip design, things like ARM or Intel do things like that. Foundries, that's things like TSMC that people might be familiar with. Cloud computing, things like Amazon Web Services, Google Cloud. So this is what we kind of, and this is adapted from Khan et al. At CSET. This is the kind of model of one model that we have for the supply chain. And I think this is very interesting because if you follow these stages, basically all of them are characterized by incredibly high barriers to entry in terms of financial cost and also tacit knowledge. And that has led to incredible levels of concentration. So let's talk about some of them. Basically, with chips, you want the smaller the node, the better. The more capable the chip is. So at the lots and lots of companies can produce things at like the 15 nanometer node, but then as it gets like more and more high tech, smaller and smaller, the number of people that can really do this like science fiction level stuff decreases smaller and smaller and smaller. So at 7 nanometers, you get ASML and Nikon. You get some of the chip makers are able to do it, but you get down to like the really, really like cutting edge stuff, the 3 nanometer stuff, and 2 nanometer in the future, and only one company, ASML, based in the Netherlands, is able to produce that semiconductor manufacturing equipment that you need, and they sell it to TSMC, which is the only chip manufacturer in the world that can produce this like very advanced stuff. So then people are making moves. People may have heard about like the CHIPS Act in the US. There was also a CHIPS Act in the EU first. They're both trying to like encourage chip making in Europe and the US. But at the moment, it's like really, really firmly only TSMC in the world is able to do this leading kind of cutting edge stuff. But we see this elsewhere. We see this in like GPUs, graphics processing units that are used often in AI training. We also see it in DRAM, which is, I forgot completely what it stands for. And then we also see it in cloud. So the cloud market is kind of quite split between China, which has its own 3 cloud providers, and then the rest of the world where the 3 US ones dominate. So you've got, big one, Amazon Web Services up here on 32%, Microsoft Azure, and Google Cloud. And together, I believe it's 60% of the market, going up to 80% for some of the more advanced things. So basically, we can see that just like all along this supply chain, there's incredible levels of concentration, high barriers to entry, which makes this thing like very, very juicy and very, very interesting to antitrust. Because like whenever you have these kinds of concentrations of power, like very high levels of market share, that gets the like spidey sense of competition lawyers and regulators tingling. So this is why it's of like strong interest to antitrust. It's also interesting from an AI governance perspective because maybe like, oh, we really don't need to focus on, if we can just focus on like some of these leading ones, which are the absolute dominant at their stage of the supply chain. So now I'm going to talk a bit about how this intersects more kind of concretely with antitrust by going through the 3. So I just showed you, but I hope that maybe does anybody remember one of these? This is mergers. So NVIDIA was about to buy ARM. They're both kind of big chip designers. This was abandoned after. So it had to get. It was NVIDIA is a like U.S. company, ARM's in Cambridge, in the United Kingdom. It was going to buy it, but it had to pass clearance in several jurisdictions, not just in the UK. It had to pass merger control regulation in the EU. China got involved. The US got involved. South Korea. Lots and lots of people raised concerns and questions, especially about like whether ARM was able to act as a neutral technology supplier. So this is like already we are seeing this compute supply chain like being of strong interest to people within antitrust. Whoops. So secondly, abusive dominance. So this is when like one company with a big market share kind of abuses that market share to cut out competitors or kill rivals or force its competitors to force its consumers to pay higher prices. So the FTC, led by Lina Khan here on the right, here in the US, is currently investigating Amazon Web Services. And this is Margrethe Vestager, who's the competition commissioner in the EU. They're also investigating over there. And in fact, there's a bill working its way through Congress at the moment on self-preferencing, which is when you, if you Google something and Google gives its services first, you search something on Amazon, Amazon stuff comes up first, and maybe they're concerned that they're using data gathered from their competitors to kind of like shut out others. So, and they're worried about also exclusivity incentives. If you're doing something with AWS, you should just keep on. You shouldn't go to any competitors. And they're concerned about bundling services. So you already get this thing, but you should get all these other services from AWS as well. Anyway, so this is just to flag that like this other aspect of the supply chain is also antitrust is beginning to look into. Cartels and collusion. I've already talked. I talked to the previous little section about that many of these agreements are cool and groovy if structured well, but if they're structured poorly, they might raise concerns. This is the diagram from this Towards Trustworthy AI Development report that I talked about earlier with some of the proposals. And then finally, state aid. Yeah, so this is most relevant to the EU, but the CHIPS Act that was passed in the EU before the US one, it kind of adapted state aid rules. So one of the commissioners, who's like the cabinet level secretary or the government minister, whatever, Thierry Breton, said, oh, we're scrapping state aid rules so we can build more chip manufacturing plants. And then the competition commissioner was like, no, we're adapting state aid rules. Very, 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 very important. So for the first time, governments will be able to subsidize the building of chip production facilities in the EU. So the recap of this paper is to just try and kind of introduce the intersection between the compute and AI hardware supply chain and antitrust as like a major topic, right? Like there's, despite it being relatively underexplored, there is like several reasons why we should be focusing on this as like a key topic of interest to both AI governance and to antitrust and competition law. And we can already see that it's beginning to intersect in very interesting ways. So that was this. So I've talked about, I've given the overview. I've talked a bit about where there might be in tension. I've talked a bit about where there may be a possible synergy around the compute supply chain. But you might be saying, well, this is all very well in the near term, but is this at all like relevant if we're talking about like as AI becomes ever more advanced and powerful? Is it just like kind of irrelevant? Will it just fall by the side? We argue it won't in another paper about this long. So this the title of this one, Effective Enforceability of Competition Law Under Different AI Development Scenarios. So the idea for this was the thing that we keep on returning back to: can competition law be a key lever to ensure that future AI development is safe and beneficial? Like, how can we reduce those tensions and increase those synergies? And clearly, one of the major questions there is, will it at all remain effective as we consider different scenarios? And of course, and this is, enables anticipatory governance, enables us to plan for the future. We don't know how AI is going to develop over the next, coming decades in terms of technically or kind of economically. So we've got to consider a range of scenarios, and we offer 6 development variables on which things might differ over the coming decades, and we talk a bit about like in which of those cases would antitrust and by extension other forms of regulation still be important. So just briefly, I'm an academic. We love definitions. Here's the definition. We're talking about 4 factors when we're talking about effective enforceability or whether regulation like really has any bite whatsoever. So the first is whether it falls within the jurisdictional scope. The second is whether there are like loopholes that emerge over time. And then the kind of more important and concrete things are whether regulators are able to detect infringements of some regulation or of antitrust. and then whether, in this case, competition law can remedy and sanction and actually like fix the problem. So whether they can spot that something's going wrong and whether they can actually address it. So that's what we mean when we're talking about effective enforceability, like whether they can, there's some loophole or jurisdiction, and then whether they can spot it, whether they can fix it. So here's our 6 variables. We've got capacity, speed of development, key inputs, model, number of actors, and the nature and relationship of those actors. So, I mean, the capacity one is like probably the simplest to explain. You know, what is the capacity of the AI system at that time? And very clearly, you know, if the system is like a very high capacity, you would expect regulation to be like less enforceable. If it's kind of lower capacity, what we have nowadays, you would expect regulation and competition law to be more enforceable. I'm not going to go through all 6 of them. You can, again, read the full paper. I'm going to go into a bit more depth about 2 of these, which are key inputs and the nature and relationship. But yeah, so the idea is we have this uncertainty about how the world's going to go, but we can kind of say, well, are these pathways to the future, are they going to be more like, are they going to be like really fast takeoff and like very quickly get to like a very capable AI system? Are they slow? Or are there like a large number of actors? There are a small number of actors. So we can say like these different things, and we can say, based on that, whether they are likely to be more or less enforceable. So I'm just going to go through 2. One is a technical variable, and this is built on the kind of previous one about compute. So it's often said that there are like 3 key inputs into AI progress and into AI market power. We've got like innovation, good ideas, better algorithms, talent. We've got kind of large levels of data, and then we've got compute. And we can kind of envisage this on a spectrum like this, where it all adds up to 100%, right? So if compute is like the major bottleneck, let's say it's got like 70% of progress can be attributed to just increases in compute. So therefore, there's 30% to give to data innovation. So this is like a pretty common way of conceptualizing it that's like you see a lot from analyses from like OpenAI, Danny Hernandez, and others. So there are several reasons. So talent, yeah, is this like talented people coming up with good ideas. There's data, gathering together huge like databases, and then there's like computing power. So it could be that like progress in the next few decades is limited by coming up with great ideas. It could be that it's limited by like gathering huge levels of data together, or it could be that it's limited and like mainly the like main driver of AI progress in the next few decades is like just huge amounts of computing power that we talked about in the previous section. There are reasons to hope that it's compute that is the like limiting factor and that is the main driver of AI progress. Why is this? Because it's easy, we argue that it's easier for regulators to detect breaches when it comes to compute as compared to if data or talent was the restricting factor, and it's easier to remedy and sanction those breaches. So computing power, it's all in this like very large data centers. It's very legible, it's quantifiable, and then you can, yeah, so that makes it easier to detect breaches. Whereas if you compare it to like data, it's much harder to like, all this data is contextual. Maybe there's certain restrictions applied to it. Maybe you can't use it in these particular areas. Talent, even harder. How do you compare like, oh, this person is worth like 100 times this person, whereas comparing like this chip is worth 10 times these amounts of chips is a lot easier to do. So that makes compute like a very promising target for people from the outside to be able to even spot that something bad is happening and that there's some concentration of power. And then it's easier also to like sanction these breaches because let's say you want to split up some company. You've tried all the other ones. You just have to go for the hardest, most powerful tool that you have, which is like structural separations between companies. Great, you say, right, you talented people will go over there, you talented people will go over there, you can compete now. It's really hard to stop people just being like, okay, well, I'm not going to continue working with this company, I'm going to go work for this third company, I'm going to go rehire here, I'm going to go do whatever. So that's what's called flight risk. you might want to with data, you might want to say, well, we'll give your competitors access to your data, but then there might be privacy concerns. There may be all kinds of interoperability concerns there. So it's much easier to do structural remedies, that kind of very clean breaks with compute, because you can just be right, these data centers belong to this company, these data centers belong to this company. So those are reasons that compute might be better for effective enforceability. Right, so that's just one of the variables we talked about. The other one that I'm going to talk about today is the nature and relationship of actors. Basically, yeah. So these are 6 options for how the relationship could be between 2 different actors. So you can have 2 private companies, and the relationship can be cooperative. You can have 2 private companies, and the relationship can be competitive. You could have interactions between states, and that could be cooperative. Interactions between states, competitive. And then finally, you could have one between a private actor and a state, a private actor and a state. So this is just to kind of show that we don't yet know what's going to happen in the upcoming decades with AI development. All 6 of these possibilities seems very open and likely to me. So this is what is the kind of nature of this actor, and then what's the relationship between them. And there are some interesting things here, right? So if it's mainly led by states, then it can be shielded from competition law under a state immunity rule, unless it's operating like a company. So that's one thing. There's oh, well, the more we're in these kinds of worlds, then the less competition law and regulation can really make a difference. There's some very interesting questions here about when you've got this kind of relationship, some sort of very cooperative thing between a national champion and a state. Does that become in practice nationalized, and then it becomes a state company? And then there's some very interesting things that you could see deployed over the coming decades. So for example, shielding your national champion and your AI companies from action from other states, or weaponizing competition law to go after the industrial base of your competitors. So I think this is gives an indication of how looking into antitrust and AI governance together can show a bunch of strategies and considerations that we wouldn't think about if we're just thinking about either of them in isolation. Okay, so to go back to the 6, again, we can talk about it more in the Q&A or in office hours or whatever. But yeah, these are the 6 kind of variables. Many of these will be clear to you. Yeah, the other one is maybe model is quite interesting. Is it more the kind of comprehensive AI services thing, which is going to be more enforceable, or is it one single agent, much harder to enforce competition law against or any kind of regulation against? I've given an overview of antitrust, so hopefully we're all on the same page. I've talked about this possible kind of near-term tension between the kind of cooperation that we might really want, and then antitrust might, if structured poorly, might get in the way. I've talked about these possible synergies where there's already antitrust scrutiny on many aspects of the compute supply chain that might continue in the future, and we might indeed want to use the power of antitrust to achieve various AI governance goals. And then I've made an argument for why, while there's still a great uncertainty about what the future holds in terms of AI development, there's still a plausible argument that in many of these scenarios, antitrust and regulation remains a important, very powerful tool of states, indeed one of the most powerful tool that states have over companies. So I'm going to end, because I've already, I'm sure, gone over what I said I would. What you can do, and apologies for this wall of text, but there's really good work done so far. It's not just me and Shinshin. It's also Cullen O'Keefe, who was at the GovAI Legal Priorities Project, now at OpenAI, does some great work on this. There's been some really good papers from CSET on antitrust and AI. So yeah, there's already really good stuff. So if you in the audience, or you watching at home, are working on AI governance, if you're at one of these companies, you're at an industry lab, you're in government, you're in academia, you're at a think tank, you're thinking about AI governance, you should be, our argument is you should be paying attention to antitrust. It's already paying attention to you. It's a very key, important tool, and both for intention and in synergy. If you're not working at any of these places, but you've been intrigued and you're one of the few people who will want to read this full thing, well, consider working on at this intersection. I think it's like a really rich intersection. It's something that we've given helpful advice to companies. There seems to be a lot of interest in this work. So yeah, why not consider working on it? Consider becoming a lawyer if you're at a student level. There are loads of great places you can do this work. Legal Priorities projects I've already mentioned, GovAI at Oxford, the Centre for the Study of Existential Risk where I work in Cambridge, CSET, which is the Centre for Security and Emerging Technology in DC. There's great places to be able to work on this question. You can cover this in academia. You can cover this in private practice at a law firm. You can cover it at a regulator like the FTC, the DOJ, or in the EU, the Competition Commission. And it's not just lawyers. I'm not a lawyer. I'm much more from public policy or from political science. There's also useful things to do there. Economics, competition law is the least legal and most economics-y of any branch of law. It's one where judges actually look at cost-benefit analyses, which is remarkably rare in the rest of the law. So there's lots of really useful stuff that one can contribute in terms of economics as well. And here's just some cool research projects that I'd be very keen for people to take up. Can we say anything about the optimal number of competitors? Do we want more or do we want less cooperation in the marketplace as it currently stands? We've talked about 14 cooperation strategies. There's lots of other ones that people have suggested. People could do analysis of that. You could deep dive into these stages of compute that we've talked about before. This ex-ante regime is coming in. It's going to change things quite dramatically. How can that new regime produce really useful information from these companies? And how can it affect behavioral change to move towards AI governance goals? And finally, maybe we could, you could do analysis of the windfall clause and other long-term strategies. So just to briefly wrap up, here's something I've been thinking about and that I've been talking about at the conference. So kind of building on this optimal number and comparison to the windfall clause. A lot of the work on AI governance to date has been around modeling races and saying, well, we really need to be careful about races at the bottom on safety. We really need to be concerned about large number of competitors all kind of, they can't cooperate. They'll race to the bottom on safety. And I agree that's a problem. However, one of the key papers in this field, Racing to the Precipice, one of the conclusions from that is that, the fewer number of competitors, the better, right? And ideally, just one, because then there's nothing for them to cooperate on, for them to compete with. I think that the history of antitrust should make us quite skeptical and nervous about that, right? When Standard Oil was the monopolist, when the East India companies were monopolists, when all of these, the interwar conglomerates in Japan and Germany had that monopoly market power, had that stranglehold on economic power and on political power. They didn't use it to produce the optimally safe outcome. They used it to produce pollution and externalities. They used it to buy the regulators, and they used that power to cut corners on safety. So I would contend, I haven't made a formal argument for this, but I would contend that while we should be concerned about 50 competitors all racing towards advanced AI, maybe we should be as concerned about just the one monopolist developing AI. So I'm happy to talk about, that's maybe a bit of a controversial thing to end on, but yeah, happy to talk more about that in the Q&A and in the office hours afterwards. Thanks so much for bearing with this in quite a hot room and quite I find it very interesting. A lot of people find antitrust quite dry. So thank you for your time, and thanks so much. Cheers.
Lovely. Thank you so much, Haydn. So we are very close to 4:30 when this session is scheduled to end. No, thank you. It's a lot of very interesting stuff to cover. Luckily, we have Haydn for a full hour of office hours in room E, right after this, starting at 4:30. So feel free to migrate over there immediately after this, and we can have a great discussion about all of this rich material. If I could just borrow you for one question before we do that. So obviously, you talk a lot about how antitrust is this powerful tool for governments to have a lever over corporations. Just to zoom out a bit to look at the entire AI governance landscape, how much do you think the focus ought to be on regulating the actions of companies and corporations as opposed to governments themselves? Obviously, like different countries have different levels of involvement in developing AI for their own purposes. And yeah, I'm curious what your take is on that.
Yeah, I think that's a really great question and a really key one. So I think we just really don't know at this stage whether the development of AI is going to be mostly led by companies, and increasingly advanced AI is going to be led by companies, for the next few decades, or whether states, governments are going to increasingly muscle in and try and direct that progress. Obviously we saw that very clearly with nuclear technology, very state-led, but things like cyber are an interesting one where a lot of the offensive cyber weapons developed in the private sector or by criminal gangs, but then how they're directed, how they're used, is often quite state-led by the US, Russia, China, others. So yeah, I think we need to be looking at all of these together, and I think there's interesting analogies you can draw between the two. So just in the same way that in the corporate world, you might be worried about just completely unrestrained competition and no cooperation on important goals, but also concerned about one dominant company that is unsafe or might misuse the technology. I think in the international level, we should also be concerned about just complete arms racing. But then on the other hand, maybe we should also be concerned about just one country claiming some right to develop and deploy this and to just take decisions on behalf of the entire world. So yeah, I think we need people looking at both of these things, but I think there's interesting kind of analogies and lessons we can draw between the two.
Yeah, interesting. Yeah, it seems like there's a delicate balancing act no matter which regime you're looking at in this governance area. So very happy that people like you are thinking hard about this already. And again, if you want to ask Haydn some more specific questions, Room E is the place to go right now until 5:30. Thank you guys so much, and join me in thanking Haydn one more time.
Great, thanks everyone. Cheers.